Come on here.
Yeah, man.
This is the situation with the non-complex case that we're putting on hold.
Yes, Your Honor. Correct.
Okay, and we'll get all that on the record?
Yes, Judge.
Okay, all right. Speaking of records, let's get on it. This is position 1924 SC 005447, State versus Favors. Mr. Favors is here in court with Ms. Rios. We have Ms. Davis for the state. Mr. Favors, it sounds like you're ready to enter a plea in your case?
Yes, sir.
Okay. We've sat through one now. You know how it's going to flow. Ms. Davis is going to ask you some questions. You'll need to answer those. And let me know if you've got any questions or if there's anything you don't understand, okay?
Okay.
All right, let's do it.
Mr. Favors, please raise your right hand. Do you swear or affirm the testimony that you will give in the matter before the court shall be the truth, the whole truth, and nothing but the truth?
Yeah, ma'am.
Okay, you can put your hand down. Please state your true, correct, and legal name for the record.
Jamar Favors.
I need you just to speak up a little bit. Spell your first name for the record.
Jamarius.
Are you at this time under the influence of any alcohol, drugs, or medication?
No,
Is there a medication that you normally take that you have not taken today?
no.
How old are you and how far have you gone in school?
19 in the 11th grade.
What high school did you attend?
Virgil Daily High School.
Are you able to read, write, and understand the English language?
Yes,
Are you a United States citizen?
yes,
Do you understand that you're charged with the following offenses? An indictment 24 SC 005447, theft by taking, possession of tools for the commission of a crime, and willful obstruction of a law enforcement officer. Judge, we are moving to null pros the fleeing and attempting to elude a police officer. There was a third co-defendant that was a minor. He was basically turned into his parents, but he was the driver. I
Oh,
know that the statute allows it, but considering the fact that he was the driver, I didn't think it would be appropriate.
yep,
Okay.
okay.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
yes,
Have you had enough time to speak with your lawyer, Attorney Rios, about all the facts and circumstances known to you in this indictment and any potential defenses?
yes,
Do you need more time to discuss this case with your attorney?
no,
Are you satisfied with her services?
yes,
Attorney Rios, do you waive formal reading of the indictment and any and all defects therein for the purposes of this plea?
Yes.
Mr. Favors, do you remember having been arrested on these charges?
yes,
Your Honor, the state isn't aware of any outstanding warrants related to this matter. Attorney Rios, are you aware of any outstanding warrants related to this?
No.
Mr. Favors, has your attorney advised you the minimum and maximum sentence for each charge to which you are pleading today?
yes,
For the theft by taking, the maximum sentence based on the amount is 10 years. For the possession of tools for the commission of a crime, the maximum sentence is 5 years, and willful obstruction is 12 months. Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court?
yes,
Do you understand the court is not required to accept the state's recommended sentence?
yes,
Do you understand the court has the right to sentence you to the maximum possible sentence on each charge?
yes,
Do you understand that there are multiple charges to which you are pleading to today, and the court has a right to run those sentences consecutively or one after the other?
yes,
Is this also first offender, Ms. Rios?
Yes.
Mr. Favors, are you asking to be treated as a first offender under the provisions of the First Offender Act?
yes,
Have you ever pleaded guilty or NOLO or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
no,
Have you ever been sentenced for a crime, felony or misdemeanor under the First Offender Act?
no,
Has your lawyer explained the First Offender Act to you?
yes,
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
yes,
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
yes,
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that is true regardless of any advice by your attorney or anyone else.
yes,
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony, which may carry a sentence from 1 to 15 years in prison?
Yes.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney in a trial of your case,
Yes.
the right to the presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes.
the right to subpoena witnesses and compel the production of evidence,
Yes.
the right to have the charges against you proved beyond a reasonable doubt,
Yes.
the right to appeal if convicted of these charges after a trial.
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for the felony charge and 12 months from today for the misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
How do you plead the charges? How do you plead to the charges in indictment 24 SC 005447 to theft by taking, possession of tools for the commission of a crime, and willful obstruction of a law enforcement officer?
Say it again.
How do you plead to the charges of theft by taking, possession of tools for the commission of a crime, and willful obstruction of a law enforcement officer?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Your Honor, we believe that if this case were to go to trial, the record would show that on June 10th, 2024, about 5:30 in the morning, officers observed a 2016 Hyundai Elantra driving in the roadway without headlights. The Officer Meha, initiated his emergency equipment, attempted to initiate a traffic stop. That traffic stop was disregarded. The vehicle was driven to Allen Temple Apartments. However, the incident occurred at 345 7th Street, Northeast Atlanta, Georgia, in Fulton County. The suspects exited the vehicle and fled on foot. Officer Mayhew was able to detain one of the males in the vehicle. He did radio for other support, and they were able to detain the other two individuals who were in the vehicle. Officer Mayhew performed a show up and positively identified all the suspects in the vehicle. When they did observe the vehicle, they noticed the steering wheel column had been tampered with, window glass had been shattered, so there was forced entry. They located two window punchers, a glove, and a ski mask. This vehicle belonged to Miss Emily Chansey. She had parked the vehicle the day before, and when she went out on June 10th to 7 o'clock in the morning to go to her vehicle, she discovered that it had been stolen. So the state is recommending a probated sentence. I believe the defendant has two cycles, both similar kind of set of facts in 2024. That second case is 24 SC 005327. We are offering the defendant 3 years probation. He'll be required to do an anti-theft course, 50 hours community service, obtain his GED, or remain employed. He is to have no contact with his co-defendants in both cases, Mr. Darshawn Taylor and Mr. Trayvon Willis. If Mr. Favors can successfully complete the terms and conditions of the probation, then the state would be moving to null pros the second case. This was a candidate that we thought would be eligible for diversion, but because of the second case at the same time, he was not able to be accepted.
Okay. Any restitution for Ms. Chansey?
I believe I did try to reach out to Ms. Chansey. I'm not sure there is any restitution, Judge, but I will confirm.
Okay, well, we'll leave it out for now. If that changes, you can let me know.
Thank you, Judge.
All right, let's talk about that. This plea hearing for Jamar Favors had a calm rhythm. But don't be fooled, there were some important takeaways. Mr. Favors, just 19 years old, entered a guilty plea for theft by taking possession of tools for the commission of a crime and willful obstruction of a law enforcement officer. The court also dismissed a separate charge fleeing and attempting to elude sentence. As it turns out, the person behind the wheel was a juvenile co-defendant who's already been released to his parents. That small but meaningful moment highlighted the judge's and prosecution's willingness to calibrate charges to reflect each person's actual conduct. Credit where it's due. That's thoughtful justice. Now, Mr. Favors responded clearly and politely to the battery of questions required to establish a knowing and voluntary plea. No hiccups. No attitude. He confirmed he understood the charges. The potential maximums 10 years, 5 years, and 12 months for the respective counts and the conditions of his first offender status. That part was especially important. As with other first offender sentences we've seen, this deal offers a clean slate, but only if he holds up his end. The judge explained that a future violation could not only lead to adjudication, but open him up to maximum sentencing down the road. That's the fine print many don't appreciate until it's too late. The facts of the case painted a pretty clear picture. Back in June, a Hyundai Elantra was spotted without headlights around 5:30 a.m. An attempted traffic stop led to a short chase and a foot pursuit. Officers eventually caught 3 individuals, including Mr. Favors, and found the car had a tampered steering column, broken window, and tools often associated with car theft, 2 window punches, a ski mask, and gloves. The victim, Emily Chansey, had parked the car the night before and discovered it was gone the next morning. All standard fare for a vehicle theft case. But what made this one a bit different was how the court handled sentencing. Rather than throwing the book at Mr. Favors, the state recommended and the court appeared ready to accept a 3-year probation sentence with several conditions. He'll need to complete an anti-theft course, perform 50 hours of community service, either stay employed or pursue his GED, and critically have no contact with the co-defendants. That's not just boilerplate, it's a real condition with consequences. And if he completes everything without a hitch, the state is prepared to dismiss a second pending case. That's huge. It shows a level of confidence that Mr. Favors can take this as a turning point, not just a penalty. Overall, the courtroom had a composed and focused tone. The judge guided things smoothly. The prosecution was professional and even acknowledged an attempt to get Mr. Favors into diversions, something that fell through due to timing with the second case. And Mr. Favors, to his credit, showed up ready. No pushback, no confusion, just an acceptance of the terms and a quiet willingness to move forward. Hopefully, that's a sign of things to come. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.